Hello, everyone, and thank you for joining Foley and Lardner for today's Distribution and Franchise webinar series titled 2020 Vision: Strategies for Success. Before we get started, we would like to make a few announcements. We will be making a few verbal announcements along with digital announcements through your Q&A widget. The Q&A widget is located on the right side of your screen. Please click Ask a Question to type into the widget. To follow along with our digital announcements, please make sure and click the Featured tab and scroll down to the bottom to see the most current announcements. It is imperative for CLE credit and attendance reporting to enter your first name, last name, and email address upon entering and exiting this webinar through your Q&A widget on your screen. At this time, please go ahead and type your credentials in the Q&A box. In addition to digital announcements, we will be sending the program materials and survey links through the Q&A box as well. Again, please make sure to scroll down to see the most current announcements. And now to review important housekeeping items and CLE information. This webinar is being recorded for post-event viewing. We will be announcing 2 separate CLE codes verbally and at random throughout today's program. Please submit this code in the Q&A widget on your screen along with your email address. Please note that if you're seeking CLE credit in Kansas, New York, or New Jersey, you must also fill out the attorney affirmation form that is located in the survey link. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webinar via email. We will be sending a link to the survey for today's program. Please complete at your convenience. We appreciate your feedback on today's program. You are welcome to enter questions at any point in the program through the Q&A widget along with your email address, and if time permits, the moderators will answer your questions verbally. I will now turn over the webinar to our moderators, Mike Lockerbie and Bobby Howell.
Good morning, everyone. This is Bobby. Welcome all of you to our 29th annual Law of Product Distribution and Franchise Seminar. I'm sorry I don't get the chance to actually see all of your bright shining faces in person this year like we have in years past. But as with everything else, COVID-19 has made us have to be a little more nimble and flexible about our format for this program this year. We hope that we will be back in person and get a chance to see all of you next year, and that you will get a chance this way to attend all of the sessions, since we won't be running on separate tracks like we do occasionally when we are in person. For those of you who I have not previously met, I am Bobby Howell. You see my picture on the screen there. I am the immediate past co-chair with Mike of the Distribution and Franchise Practice, and have been hosting this seminar for almost 15 years now. So I've gotten a chance to meet many of you in person, and I've really appreciated that. And I again look forward to doing that again next year. I hope that you will enjoy the materials and the information that our presenters will be providing based on the experience that they have developed over the years in assisting many of you with your distribution and franchise issues. In addition to my membership on the Distribution and Franchise Practice Group, I'm also a member of our antitrust practice, our automotive industry team, and our manufacturing industry teams, and I'm a partner in the litigation department of our Madison office. You will be hearing from folks from a number of different offices around the firm, and with many different practice and industry group affiliations, and hope you will take advantage of the breadth of experience and information that you're going to be hearing today. And with that, I'm going to turn it over to my colleague, Mike.
Thank you, Bobby. As Bobby mentioned, I am one of the co-chairs of our National Distribution and Franchise Practice Group. I'm not going to go through my bio. It's on the web. I have met many of you live. I work out of the Washington, D.C. office, with the operative words these days being out of the office. I have not physically been in the office since March 4th. And these internet webinars, hearings in court, depositions, and the like, for better or worse, are the way of the world right now. We will be interested in hearing your feedback. Obviously, we had no choice in doing it this way this year. Next year, hopefully, we will have a choice, and we'd be interested in knowing whether you prefer the live format, internet, or perhaps if you'd like to have the option of doing either or both. In any event, with that, I have a couple more housekeeping items to run through before we get started, and don't want to delay the substantive presentations anymore. In terms of a few other housekeeping items, if you experience any technical difficulties with the webinar platform, and that does happen, first try refreshing your browser or leave the meeting and come back in. If that doesn't work, there's an email on the screen, videoconferencing@foley.com, and hopefully they'll be able to get you back in. We are going to be sending out a copy of the written materials and the slides after the event. However, also, if you look in the Q&A widget in Microsoft Teams, you should be able to access those materials in real time. And last but not least, especially for those of you who want CLE credit, if you haven't already done so, you'll need to submit your full name and email address, and there will be some other times during the webinar when you will need to do that as well. Unfortunately, because of the platform we're using today, we can't take oral questions, but there is a Q&A widget on the screen, and time permitting, we will answer those during the course of the seminar. If time does not permit, if you could please include your name and email address, we'll get back to you after the webinar. So with that, I think we ought to launch into our first presentation by Leslie Smith, whom many of you also know. Leslie is based in the Miami office, former member of the governing board of the ABA Forum on Franchising, and is no stranger to these annual seminars, and also presented at one of our distribution and franchise coronavirus webinars that we put on over the summer. And with that, I'll turn the floor over to Leslie so you can hear what she has to say about force majeure clauses, which, needless to say, have received a lot more attention in the age of coronavirus than many of us did since first year of law school.
Well, good afternoon, everyone. Thank you, Mike, for the introduction. And Bobby, I'm happy to be back speaking again. I wish we were all in person. I am speaking to you from my office. Unlike Mike, as soon as we were able to reopen our office in mid-July, I was the first attorney back, and happy to be here. Florida is an interesting place right now, as you can imagine, and we're hoping to weather the return to our schools, starting public schools on Monday. But for today's discussion, I thought we should talk a little bit more about force majeure. And, you know, I'll just start, if I could start with the next slide. For some of you, most of the lawyers in the House will have heard about this and these provisions, and you probably generally, the rest of you have heard about these clauses. They're very common in all kinds of commercial agreements. And basically the purpose of these is to excuse one party or both to a contract from performance. And those are typically defined contingencies, but they are typically those that are beyond the control of the parties. And because they are contractual provisions, they do not arise from common law, the specific language that the parties use in them becomes very important. And this is particularly true because, as we'll see through our discussion and roadmap through a number of cases this afternoon, courts tend to strictly construe these provisions. Can I have the next slide? So, you know, the kinds of events that force majeure clauses are typically covering, and what you typically see in them are extreme weather, what they call casualty, condemnation, wars, strikes, acts of God, and sometimes governmental regulation. but much less frequently will you see things such as the terms disease, pandemic, epidemic, quarantine, curfews, etc. So as we go forward, we'll see why this should make a difference. Next slide, please. And I thought by way of background, it would be interesting just to sort of look back and say, you know, when do these force majeure clauses really come to the forefront on a large scale, not in just individual one-off types of situations. And I think the last times that we can really recall having seen these presented to the courts in particular have been events such as 9/11 and the Great Recession back in 2008. So let's talk a little bit about a couple of cases and how the courts were looking at these provisions at that time. The first case I'm just going to talk about briefly is the Travel Wizard case. This was a case involved a travel agency. It had chartered a cruise. They were going to go down to Australia and see a solar eclipse. And of course, that was scheduled for November of 2001, right after 9/11. The cruise was not ultimately canceled, but they didn't go to Australia to see the solar eclipse. So there was a fight between the parties about how much they should have to pay for this chartered cruise. It ended up in arbitration. Clipper prevailed, and Travel Wizard went into court and said, I want to stop the effects of this award and get a TRO. And the court said no. It said, look, you know, a force majeure clause doesn't protect you here, because really all that you have here is a situation that has become performance, you know, was made more difficult, and it might have been economically inadvisable, but it wasn't prevented. So the court in that instance didn't view the events as excusing or barring performance. The next case, Elavon versus Wachovia Bank, comes out of not 9/11, but the Great Recession of 2008. And what happened was Elavon was providing credit card processing services for Wachovia Bank. You all may recall, those of you who were around then, that Wachovia Bank is no longer. It was swallowed up by Wells Fargo as a result of the Great Recession. And Wells Fargo's had credit card services through another company. So Elavon was not receiving the services that it had before from Wachovia's customers that had been swallowed up into Wells Fargo. It went into court, and the court said, look, it didn't find that the force majeure clause was protecting Wachovia, who said, look, I've just been swallowed up by another bank, and, you know, performance is not within my control. And the court said, well, that's not entirely true. You know, you chose to refer your customers to the Wells Fargo processing centers, as opposed to back to the original contractual party, and it didn't give the green light. Elavon actually prevailed in that instance, and force majeure was not deemed sufficient. Next slide. Just a couple more very briefly. The Flathead case was a lawsuit involving enforcement of a construction loan and guarantees, also following the 2008 downturn. And the defendants sought to amend their pleadings. They wanted to add affirmative defenses, including force majeure, and the court said no. The court said this is a defense that is inapplicable to financial hardships. And then in Route 6 versus Ruby Tuesday, that case, Ruby Tuesday had contracted with Route 6 to build a restaurant on an out parcel, and they were supposed to do that by March of 2009. Again, right after the Great Recession took hold in 2008. Ruby Tuesday kept paying the rent, but it didn't construct the restaurant. The landlord was unhappy and went into court to sue. And Ruby Tuesday said, listen, wait a minute. You know, as a result of the crash and the recession, we've had a major decline in our stock price. We've had to reclassify our debt, and we really need this money to pay down our debt, as opposed to paying you and building this restaurant. That didn't fly with the court either, because even though there was a force majeure clause that had broad reference to events beyond the party's control, the court held that Ruby Tuesday made a calculated choice to allocate its funds to the debt as opposed to building the restaurant. So next slide, please. So as you can see, you know, here we are. We've been through Great Recession. We've been through 9/11. cataclysmic events for our societies and our economies, and the courts are not really very warm to the idea of force majeure clauses to the extent they impact the economies between the parties and choices that are made to perform or not perform. So how are the courts going to be treating the 2020 pandemic that we're in right now? I think what we're going to probably see, and we'll see some cases following here, is the courts are probably going to focus on what's unforeseeable, and also in this sense, timing becomes very important. You'll see closer in time or even after in time contracts entered into may not get a pass or enforcement of a force majeure clause, whereas earlier entered contracts might. Was the deficiency in the performance really beyond the party's control, or was it simply just a function of impossibility of performance? So these are all the factors that courts will be looking at. So with that, next slide. And I thought, to my amazement, when I started looking at cases for this presentation, there have been a lot of cases filed over the last few months. Next slide, and we'll talk about a few of those. And I'll sort of talk about them in terms of categories and how the courts are viewing these types of force majeure clauses and what the parties use them for. And first I want to talk about cases where parties are invoking the clause to avoid the termination of their contract. And the first case is the Via Media case. Via Media sells, television advertisement. It sells it to small businesses on behalf of television cable companies. And Via Media was obligated to pay a minimum revenue to the defendant. When the pandemic hit, not surprisingly, most of Via Media's opportunities for advertising, which came from live sporting events, political campaigns, automotive events, just sort of dried up or were curtailed by these state orders that shut down businesses and canceled public events. The defendant said, listen, I want my money, and he terminated the agreement. Via Media went into court and wanted to see a TRO. The court, however, said, listen, there was no irreparable harm here. The court said Via Media's injuries are essentially economic in nature. And what was interesting, and of course, mostly a function of a TRO and the balancing of harms test, the court said, look, this account only represents 12% of Via Media's advertising revenue. It's not faced with insolvency. And so the court denied the TRO in that instance, despite the effects, the very severe effects of the pandemic and the presence of a force majeure clause in the parties' agreement. Next is the E2W case. This is a franchise case. The plaintiff had agreed to an area development schedule. It was going to open and operate at least 10 franchises. The franchisee needed third-party financing to do that, but the lender backed out as a result of COVID. So the Z didn't open the required franchises and wasn't getting those underway. It didn't have its financing in order to even start the process. And the defendant franchisor issued a default notice and also terminated the parties' agreement. Franchisee went in for arbitration, but also ran into court to enjoin termination pending arbitration. And basically arguing, look, its force majeure clause excused its non-performance because it was due to, it said, an act of God and a governmental order, which were phrases in that particular force majeure clause. The court, unfortunately, we don't have any discussion by the court, but it did in fact grant that TRO in that instance. So we'll have to see how that one further plays out. The JN Contemporary Art case is an interesting one. This was an art gallery owner that had contracted with the Phillips auction house to sell a valuable painting. It was going to occur at an auction that was scheduled for May of 2020. And in return, the gallery was going to receive a guaranteed minimum price. Due to the impact of COVID in New York City in particular, Phillips canceled the auction and it terminated the parties' contract because their force majeure provision stated that it could do so if the auction was postponed for events, quote, beyond our or your reasonable control. And went on to say that in that event, that Phillips could terminate the agreement and not make the guaranteed minimum payment. Well, the gallery owner, when it got this notice, was not particularly happy. It sought a TRO to prevent Phillips from terminating that agreement and requiring Phillips to go ahead and sell the artwork at its next auction. And the plaintiff said, look, the defendant's decision to terminate was not really a result of the pandemic. It was worried that it wouldn't get the guaranteed minimum and still have to pay it to us. So there's an interesting finding there. The court said, look, it denied the gallery owner's motion and said the plaintiff hasn't established that it will suffer irreparable harm in the absence of a mandatory injunction, and that monetary damages wouldn't compensate it, and therefore denied that request for the TRO, for a mandatory TRO. Next slide. Now, on the flip side, there are parties who are trying to use the force majeure clause to avoid termination of a contract and as grounds for a termination of a contract. And so in the next instance, the Sodexo case, this involves probably close to Mike's house. This is Sodexo, the food provider that had contracted with the Virginia Aquarium, and it was going to manage its food operations there, and it was doing so. But with the onset of COVID, the city of Virginia Beach announced it was going to shut down a number of recreational facilities, including the Virginia Aquarium. And after it was closed, after 45 days, Sodexo terminated the parties' agreement and demanded that the Virginia Aquarium pay back the unamortized portion of their capital investments that they had made in the physical plant there at the aquarium. Virginia Aquarium refused to make those payments, and Sodexo filed suit and claimed that the force majeure clause in the parties' contract permitted the termination because it was permitted to terminate for specified force majeure acts, such as acts of God, which it argued was similar to a pandemic, and the governmental policy that had come about, which was, of course, the directive by the city of Virginia Beach and Governor Northam's orders, which prevented the performance. So that one is still playing out as well. The next case, which is the N88JK case, this is an interesting case insofar as the plaintiff here was the owner of a used aircraft, had a plane. It entered into a contract with the defendant who was going to purchase that aircraft upon conducting certain inspections and a test flight. This purchaser gave a $500,000 deposit, and there was an agreement that was signed which allowed for no liability in the event there was a failure or delay in performance, which was due to an act of God or governmental actions or any other cause beyond the affected party's absolute control. So in March 2020, the inspections hadn't happened, and the defendant purchaser sent a notice of termination saying that it wasn't going to purchase the aircraft because a force majeure event had taken hold with the worsening global pandemic. And it said it's led to multiple travel bans and states of emergency, including the United States, which is where the airplane was located. Subsequently, the buyer said, I've got also a different force majeure event, which is the fact that my personnel, who were Nigerian nationals, had left the country before they could conduct the test flight. Well, the buyer wanted back its $500,000 deposit, and the seller refused to return it. And it went into court and filed a DEC action to ask the court to declare that no force majeure event had occurred because it argued the defendant, the purchaser, could have conducted the test flight, and his personnel had voluntarily elected to leave the country prior to doing so. So that's another one that is still ongoing. The Banco Santander case and versus American Airlines involves the bank, a Brazilian bank, and it had entered into an agreement with American Airlines under which it was going to have to co-brand credit cards, etc. And it was required to purchase a certain number of miles from American Airlines as well. As a result of the pandemic, American Airlines stopped flying to Brazil, and the bank said, listen, I'm terminating this agreement because it's a force majeure event, and I don't think I have to be required to continue to do this. As a result of that, the American Airlines said, well, listen, the problem with your argument here, bank, is that flying to Brazil without interruption wasn't one of our contractual obligations under the agreement. So it'll be interesting to see that one's in a motion practice right now to see how the courts will rule on that and whether that argument by Banco Santander will carry weight. Next slide. Okay, I'm going to have to go much more quickly than I realized, so to get you through some of these topics here. This is using the force majeure clause to extend or compel a closing obligation. And let me actually talk about Pacific Collective versus ExxonMobil first. That was a developer. He was going to purchase property in Los Angeles. Exxon knew that. The agreement was supposed to be closed in March. The developer said, listen, I'm going to go forward, but I can't go forward right away. Exxon sued and the agreement was terminated, and the developer sued to enforce the transaction and its interpretation of the force majeure clause. It didn't want to lose the opportunity. It just didn't want to close in the same time frame that ExxonMobil did. And in Forescout, that case involves a publicly traded company that was going to enter into a merger with a defendant. It was a $1.9 billion transaction. The agreement was actually executed after COVID was declared a global public health emergency. The closing did not occur. And of course, when that sale failed to close, the plaintiff went into court seeking specific performance and said that the court shouldn't allow a private equity buyer to walk away simply because it wasn't going to make the same profit as quickly as it had anticipated. That case involved a force majeure clause wrapped into a material adverse effects provision. And we'll have to see where the court comes out on that, because excluded from material adverse effects was pandemics. So the last case on this slide is the Cannes case. Cinemex is the Mexican movie chain that came into the United States a couple of years ago. They were set to buy a bunch of theaters in Texas as a result of the pandemic. Cinemex refused to close, and the buyers sought specific performance. What was interesting here is that Cinemex claimed it couldn't inspect the theaters and therefore couldn't close. The buyer responded by saying, listen, you could have done this inspection virtually. I offered video technology for the inspection, which was not permitted. Cinemex is now in bankruptcy, so we'll probably figure out how that will end. I'm skipping over the next slides, and let's go to the back. Those next slides, and you'll be able to read these and skip over the next slide. Thanks. And one more. I just want to get to my takeaways because I'm at the end of my presentation. But basically what I just want to leave you with is, as you think about force majeure clauses, you need to think about whether COVID is a triggering event under your clause and whether you need to anticipate and have that language in your clause going forward. And you need to examine whether it's just going to delay or prevent performance and what bells and whistles you put in your provisions when those things occur, because there are provisions that allow a delay in performance or an abatement, or there are provisions that allow full-on termination. So you have to select your remedies within your clause in order to protect yourself. And also, next slide, I think it's just important to remember that force majeure clauses are not always a help. Sometimes they're a hindrance, and they might undermine another provision within your agreement. So be cautious. If you have an allocation of risk, for example, in the event of a fire, and one party has to repair the warehouse, whatever it might be, the force majeure clause might undermine that obligation. Again, connect the dots. If one side evokes the clause, does it excuse the other? And what's the impact on all of the other obligations, whether they be fees, delivery dates, or penalties? And does it allow for price adjustments if force majeure events? And finally, does it allow for termination? And do you want termination to occur in the event of force majeure? So I think that it's safe to say going forward, we'll never quite look at force majeure clauses the way we did prior to the pandemic. So thanks for your time today. I appreciate it. And I look forward to catching up with you next year. Thank you.
Thank you, Leslie. I actually wasn't aware of this Sodexo case, but now I know if I want to go to the Virginia Aquarium during the pandemic and want to eat lunch there, I'll have to bring my own fishing rod. I see so far we don't have any questions yet regarding force majeure clauses, but if people have them, please submit them through the Q&A feature, and we'll try to circle back to those later.
Okay, since we don't have any questions on this presentation, we'll move right along. Our next presenter is Vanessa Miller. She is a partner resident in our Detroit office, and Vanessa is also a member of our manufacturing and auto industry teams. Vanessa is also one of the movers and shakers behind our Coronavirus Resource Center, which many of you have likely looked at and found very helpful. Vanessa is going to be talking to us this morning about bulletproofing your supply chain and strategies to mitigate risk. And with that, I'm going to turn it over to Vanessa.
Thank you, Bobby. Good afternoon, everyone. Thank you for your attention. I'm going to talk about a very timely topic in regards to, and it relates to force majeure and other contractual provisions. But increasingly in the last 2 years, and certainly in the last 6 months, there has been an increased focus on supply chain. Not just mitigating risk in the supply chain, but really looking at the supply chain and certain efficiencies that companies can have as an asset to the manufacturing company. COVID-19 certainly was the epitome of a stress test for weaknesses inherent in the supply chain. So many companies operate on a just-in-time basis with sole sourcing across their global supply chains and specially manufactured parts. And COVID rippled up and down supply chains, wreaking havoc and causing major issues. For some companies, they couldn't get subcomponents to complete assemblies or raw materials, and various suppliers were outright shut down. For example, being in Detroit, I work with a lot of automotive suppliers, and many auto companies were completely shut down for at least 8 weeks. Other companies could not get materials and components fast enough. Beyond the grocery store shelves being drained of food and canned goods and frozen pizza flying out of there, plants and gardening equipment, gym equipment, bicycles, even home furnishings, we're seeing unprecedented upticks in orders. So even within industries, there really became very stark differences. In fact, I recently attended a roundtable event with executives from the fashion industry that were discussing how they fared at the beginning of the pandemic and challenges they had to navigate. And what we found is even within an industry, there were differences. High fashion and business attire dropped off, but leisure wear, pajamas, and athletic clothing skyrocketed. So outside of the extreme and ongoing sources or conditions of the pandemic, it really is a valuable exercise for companies to look at their supply chain from the point of the beginning, the point of contracting, through the point of litigation, where things really broke down, to think about best practices and lessons learned and where there's room for improvement. Next slide, please. So the very first step to understanding changes or improvements that might be warranted in the supply chain is understanding how commonly supply chain disputes arise. Here are some of the things that we see. Call these the usual suspects of what happens that ultimately leads to a breakdown. But I think of these really as traps that companies can unwittingly step into. And many of these things, companies are operating business as usual until an issue occurs. And then it becomes a major issue and changes are made. So it's important to think about making these changes before the issue arises. So one of my favorite quotes about contracting, and there's not that many quotes about contracting, so maybe it's one of the only quotes about contracting, but it's by a science fiction author named Charles Stross, and he says, "Contract law is essentially a defensive, scorched earth battleground where the question is, if my business partner was possessed by a brain-eating monster from space tomorrow, what is the worst thing that they could do to me?" And that's a really important thing to keep in mind, because oftentimes you'll have these really strict contractual terms, and the parties have never had an issue before, but if an issue arises, the contract is going to be very important. So what are some of the vulnerabilities that can happen? Some of them are at the beginning of a contract relationship, when a company fails to properly vet its suppliers, inspecting the manufacturing facility, running a formal or informal litigation search, having insight into the company that you're partnering with, probably a long-term partnership, multiple years, having insight into that company's financials, and that you're going to be relying on this company for critical volumes of sole sourced parts. Another area is poor contract management. We'll see that throughout the course of the contract, parties aren't holding each other to the standards. They're not enforcing defaults. They're not tracking breaches. And these are things that can cause issues down the road. Relying too heavily on boilerplate terms and conditions. Not every written agreement, of course, can be specially negotiated. Sometimes you have to rely on forms, but you have good forms, RFPs, quotations, but the same contracts that are used to, like a purchase order, for example, that is used to buy pens for the company or to stock toilet paper, should not be the same purchase order used to buy a specialized $2 million piece of machinery. Beginning performance without a finalized contract. We see this all the time. Engineers want to launch into development and qualification before the commercial team has really finalized the critical terms that are going to govern specifications, responsibility, liability, risk allocation. So it's important to have those terms nailed down, particularly when there's joint development that the parties are working on. Pricing disputes. Cost is the driver always, but we see more pricing disputes because companies fail to think about changes that might occur that might impact their bottom line and their profitability. Force majeure issues, Leslie described those in detail. Termination. That's the end of the contract. In the beginning, the parties are trying to make the sale, trying to get the business, and working together. Everything looks great. It's the honeymoon phase. Then the contract plays out. There's quality issues. Things go wrong. You don't get the volumes as a seller that you were expecting. Lots of disputes arise at the termination phase. And finally, warranty issues and recalls, where massive liability really can occur for manufacturing companies. Next slide, please. So what is the second step? Well, it's really recognizing common obstacles. These are things that you probably can't completely avoid, but you might be able to think about who should bear the risk and recognizing these things as just unavoidable. Lengthy business relationships that may make it very difficult to transition into a new supplier. Ongoing business relationships that make it contractually impossible because you might have a long-term agreement and an ongoing existing contract that you can't terminate unless you have cause to do so. There likely has been turnover in the teams that were involved. In manufacturing, there's lots of turnover. A different project owner, a different plant manager, and things that might make gathering information difficult. Finally, the ultimate issue that we encounter is where one party, as the customer, even if the customer is wrong about and is actually to blame, or they're trying to push down liability in the supply chain, the customer may still insist that the supplier bears responsibility for an issue in order to be considered for future business. Next slide, please. The third step in identifying contract documents. This is critical. This is really the starting point for what you can do and can't do under the contract. might be a long-term agreement or a master supply agreement, and you need to collect all of the amendments that have occurred over the years. Otherwise, it can just be forms, purchase orders, and incorporated terms and conditions. It's important to also look for things like specifications, drawings, and requirements, particularly where there's a warranty issue or a quality issue. And then also the supplier handbook or supplier manual that might be mentioned in fine print in the terms and conditions of the buyer. It's important to have that document. What does it say? What else are we obligated to do besides just provide components? And then finally, the course of dealing. Now, this is something we talked about, companies failing to enforce certain penalties and defaults a few minutes ago. Regardless of what the contract says, what's in the four corners of the document, if the parties have been conducting business in a certain way with no regard to the contract, they haven't been enforcing penalties, or they haven't been requiring the supplier to do X, Y, or Z, this course of dealing can have a very strong impact on what a court is going to find the parties actually agreed to do. Next slide, please. Fourth step, navigating other stresses on the supply chain. Some of these are, again, completely unavoidable, but they need to be considered. The global nature of most manufacturers' supply chains that has inherent logistical challenges, political risks, impacts of local law on critical supply chain terms, currency risks and fluctuations that may occur, tariffs and trade wars. Certainly, we've seen since 2018 a number of companies becoming increasingly concerned about how tariffs and the trade wars are impacting their existing contracts. And we've in fact seen a movement away from China as a result since 2018, and looking at other options for supply chain partners and other manufacturing partners. Natural disasters. There are some locations that are more prone to natural disasters than others, and it's important to think about that and the risk and who should bear it when you're contracting. Commodity and raw material fluctuations, very important to avoiding future pricing disputes. We've seen some indexing provisions built in to avoid these sorts of things, but just thinking through it and which party should bear the risk. Is it going to be fixed price for the life of the part, life of the program, or are we going to talk about reasonable increases or decreases depending upon fluctuations that may occur? And then enforcement concerns. As we're global, how do you enforce your contract? If you have a supplier located at somewhere abroad, and that supplier has no assets here, or that customer has no assets here, how are you going to enforce your contract, adjudicate a dispute? Is international arbitration something that you should consider? And then more now than ever, cybersecurity issues are important. Making sure there's data protections in place and privacy and data protections, and making sure that your supplier or customer treats your information and has the protections necessary as they would their own. Next slide, please. Okay, so now we're going to turn to some of the strategies that you can use. And these are fairly high level, and I'm covering a lot of ground, but I want to just walk through each of these areas, which could probably be a full 20-minute presentation, each one. First is the RFP vetting and contracting process. So this is at the outset. What are some things you can do before you even start to negotiate a contract with a supplier or a customer? Particularly from the buy side, having financial audit rights, where you're relying on a supplier for 100% of your volumes, for critical components. You want to have some sort of audit rights to make sure that their operations are sound. A litigation search. This doesn't need to be something that you employ a paralegal for, and you don't have to have anything too fancy to do a litigation search. You can actually just Google companies and see, have they had a lot of litigation filed against them? Have there been quality issues, payment issues, other things? And then contract terms. Again, this is what governs the relationship, and there's some key red flag provisions that procurement and sales teams should focus on when they're negotiating, and they're listed here. Warranty. That's what the seller is promising to the buyer. Indemnification. Typically, this is for third-party claims, but it's very important to protect the the companies from any issues that the other party actually caused. Damages, considering disclaimers and caps or other limitations on liability. Intellectual property. Will IP be created? Are the parties engaging in some sort of joint development? And if additional IP is created during the course of the relationship, who owns it? Best to think about these things at the front end. And then venue and choice of forum, as well as the right to seek injunctive relief to ensure things like continuity of supply or emergency relief for trade secret theft, etc. Next slide, please. Strategy number 2, overall procurement practices. What is the procurement group doing? Work closely with the procurement department to really understand the strengths and weaknesses and pinpoint where issues can occur in the supply chain. We're hearing a lot about supply chain mapping. That's understanding not just where your suppliers are located, but also where their sub-suppliers and their sub-suppliers are located. Many companies will have transparency 1 tier down, but beyond that, they have no idea where parts are coming from or how long it takes to obtain those parts. That's probably because a lot of companies treat their own supply chain as proprietary, but I think with COVID, we're going to see more companies demanding additional transparency to be able to issue spot and identify where problems and breakdowns can occur sooner. Okay, just in time or the bank of parts warehousing option. Many companies are now requiring a certain level of warehousing or inventory banks that are either stored on site at their facility location by their suppliers or are available at their suppliers' facilities. Considering whether sole source or dual source is more appropriate. Of course, you have benefits to doing sole source because of the volumes, but more flexibility with dual sourcing, qualifying 2 different sources. The ability to in-house certain operations and manufacturing functions if there is a breakdown. We saw a lot of companies do this during COVID. And then one that's critically important is consistency between the buy and sell side. For all of the liability and risk that we're giving away on the sell side, make sure that you're receiving similar terms on the buy side. For example, I recently had a situation where a buyer was told by its supplier that it needed to declare force majeure because it was unable to deliver parts. The supplier's sub-supplier had just outright refused to continue shipping under a purchase order because it wanted a higher price. Well, that supplier had failed to obtain fixed prices from its sub-supplier. It failed to issue a purchase order for the life of the part, life of the program, a requirements contract, and now was opened up to these price increases it didn't want to pay. Well, it had given away on the sell side a fixed price contract. So the supplier should be responsible for any delta where it failed to shore up its own contracts. Next slide, please. Strategy number 3, training and contract management. People are at the heart of contract disputes, so it's critically important to make sure that they understand the contract and what it means, that they understand their negotiation leverage, and then any pitfalls. And then email training is critical in this regard as well. Next slide, please. Managing termination. As I said before, this is a major area of contention because the leverage of ongoing business, of future business, might be gone. The parties might have ceased doing business together after this contract ends. So it is really helpful to have in place some form of an exit agreement. It's important to have something about a cooperation clause in your initial contract saying that the parties will work together if there is a wind down or transition. And then after the contract does end, develop a more fulsome exit agreement that explains exactly what each party is getting. It ends the relationship. Maybe there's some quality issues that are on the table, and maybe in exchange for that, you might pay for some additional obsolescence. There's some give and take that can have the parties amicably walk away from a long-term supply relationship. Next slide, please. Finally, and this is important, litigation avoidance and early intervention. These are lessons learned, but these are lessons learned the hard way. What are some of the recurring themes or litigation patterns that the company has experienced? I think that employee training is critical. In any litigation that I've been involved in, there's always 1 or 2 emails that the other side will point to. And those emails seem so damaging for the case. But in reality, it's that there's thousands of emails exchanged between employees. And during the course of discovery and exchanging hundreds of thousands of documents, of course, you're going to find a couple of emails where someone was panicking, where someone was in the middle of investigating a complicated root cause, and they were wondering if maybe the issue could have been something they did in their plant, some quality failure or other problem. But then later on, the investigation goes on and they say, no, it wasn't our fault. But that email, rest assured, the other side is going to be pointing to it. See, you knew you had quality issues in your plant. So these are the types of things, training employees and engineers to analyze things, and of course you want to get to the root cause of the issue, but when you're exchanging daily communications about it, wait until you have conclusions before you start jumping to conclusions. That's so important with engineering training, particularly if there's a breach of warranty or recall claim, because the engineers are going to be preparing the root cause analysis document, whether that's the 8D or the problem reporting document, and that document will become a focal point of any future breach of warranty or recall claim. Looks like I'm at the end of my time. I have one question here that I see that I want to get to. Any tips on how to enforce a most favored nations clause when suppliers will not or cannot share pricing they give their other customers? So that's a very good question. Usually there should be an audit right that is included, but recognizing that there's confidentiality, there should be a way that you can still test in the marketplace. Oftentimes these most favored nations issues arise because you find out in the industry that they're offering a better price. Most favored nations clauses are particularly tricky because it's usually not just about the cost. The other side will say, well, it's also volumes and there's other pay terms and things that this party is offering me, which makes it not really similar and not really comparable. So it's important to define in that most favored nations clause what is similar and what is comparable, and what will we be allowed to look at and share to test this if we believe that you're offering a better price somewhere else. Thank you everyone for your time and attention.
Thanks, Vanessa. I think we are going to be giving everyone a CLE code at this point, and I will turn it over to the folks with those codes.
Thank you, Bobby. At this time, I will announce the first CLE code. For those seeking CLE credit today, please type the 5-digit code into the Q&A box with your credentials and hit send. We have also sent the survey link that includes the attorney affirmation as well. The first CLE code is VKMNA. Again, that is the V as in Victor, K as in King, M as in Mary, N as in Nancy, and A as in Apple. It is imperative you input your email address and this CLE code in the Q&A box in order to receive credit for today's program. Again, the first CLE code is VKMNA. Thank you. And I will turn the presentation back over to the moderators.
Thank you. All right, our next speaker this morning is going to be David Lucy. Dave is a partner in the litigation department in our Milwaukee office, and Dave has a a long and successful practice in litigating non-compete and trade secret type cases. And today he's going to be talking about that issue here with his presentation being entitled Seeing the Forest in the Trees, Finding the Path to Enforceable Restrictive Covenants. David.
Thanks, Bobby. It's a really tough act to follow the CLE code announcement. I know that many of you have been waiting on the edge of your chair for that information and probably have lost interest now that I'm speaking, but I'll do my best. Can we go to the next slide? So I'm going to talk about the forest, which will be kind of a general outline of non-compete law. And this may be familiar ground to many of you. I hope this will serve as a refresher and a good introduction for those of you who aren't familiar with this area of law. Next slide. There are two essential tenets of our legal system and society that are at issue here: private property and the right to exclude other people from using property, and free enterprise, the freedom to make contracts, the freedom to pursue a livelihood. Next slide. And this is where these tenets collide. And sort of on the property side, it's what can you claim as property with respect to a business? If you have some kind of really unique or specialized business method, yes, you can claim that as property. But if you're trying to claim the knowledge and skill of your employees as your property, the law is going to tell you no. And on the freedom of contract side, how far can you go in binding yourself or someone else not to exercise their right to compete? Next slide, please. So these issues obviously have been around for a long time, and the common law has developed over many centuries solutions to these problems. And on the property side, it's the law, primarily the law of trade secrets, and law with respect to enforcing confidentiality agreements or non-disclosure agreements, which generally say there has to be something novel, there has to be something somewhat unique or detailed about information if you're going to claim property in it. Just general knowledge is not property. And on the issue of contractual restrictions on trade, the law generally holds those to be enforceable, but only if they are reasonable. Next slide. So this is primarily a matter of state common law. And although I think almost all states adhere to this rule of reason approach with respect to restraints of trade, they vary greatly in how that rule of reason is applied, whether under some circumstances the common law imposes a per se rule, and also there's statutory provisions of all kinds that operate in this area. Next slide, please. And just going back for a second, one major recent exception to the idea of this is all state common law is the Defend Trade Secrets Act, which came into force in 2016, and we're now seeing trade secret cases routinely get filed in federal court under the DTSA, and so a growing body of federal trade secret law. It's primarily consistent with the Uniform Trade Secrets Act, which most states have adopted, so not a big change in the law, but still one area where this is federal law has come into much greater play. But talking about this rule of reason that applies to restraints of trade, and this is sort of a general multi-state description of it. it is that any restrictive covenant has to be ancillary to an otherwise enforceable agreement. It has to be necessary to protect the covenantee's legitimate business interest. It has to be reasonably limited in duration and scope, either geographically or some other way of defining a market, such as a list of customers. It can't be too harsh as to the covenantor, and it can't impose harshly on the public interest. This concept of ancillarity is one that's often overlooked. In some states, and Texas is a good example, the ancillarity requirement is given very special attention. So it's not just enough that your non-compete clause is a part of a distribution agreement or a franchise agreement. It has to be actually connected to some other part of that agreement that would justify the clause. So, for instance, in Texas, the courts have said you have to have a commitment to share trade secrets in the contract if you want to use trade secrets as a justification for a non-compete. So it's not good enough to have some kind of recital in the agreement that the employer has, or the franchisor or the manufacturer has valuable trade secrets. There actually has to be a contractual commitment to disclose those if you're going to use that to justify the non-compete restriction. Next slide, please. The case law in this area of restrictive covenants tends to be not on distribution agreements generally. The majority of the case law is on employment-based non-competes. There's also a significant body of case law on sale of business non-competes. And even in our area of distribution and franchise, almost all of the cases are in the franchise context. So if you are engaged in distribution by some other method with a manufacturer's rep or independent dealers, there's going to be very little case law out there for you to consult. Some of it's addressed in the outline. But you may find yourself in a state where you have to analogize to one of these other areas of law where the rules are more well developed. So let's go to the next slide, please. A key question is, what is the protectable interest that a party invokes to justify a restrictive covenant? And the most commonly recognized ones are some goodwill that's been developed by the franchisor or the manufacturer or the employer, and the person making the covenant has gained an association with that through the relationship. So the easy example is in the employment context, where you have a salesperson and you've paid for, you, the employer, have paid for the expense account of that salesperson. You provided a sort of back office support to that salesperson, so he's able to deliver on all the promises made to a customer. And through those investments, you've helped that salesperson develop the goodwill with the customers, and you're entitled to be protected from the salesperson taking that away and using it to compete with you for a limited time after employment. Another widely recognized protectable interest is trade secrets or confidential information. And on a lower level in terms of the prevalence of recognition is, have you imparted some specialized training to the covenantee, whether it be a manufacturer's rep or a dealer or a franchisee, that you should be protected against specialized training being used adversely. And again, it has to be something highly specialized, and that's why the recognition for this interest is relatively limited, because of that proposition we talked about earlier, that general skills and knowledge are not protectable as property and not something you can restrict someone from using in competition. And the nature of what protectable interest you invoke to justify a restriction helps determine the scope of the restriction that you can enforce. So for instance, if you're focused on customer goodwill, your covenant probably needs to be limited to the market area in which that goodwill is developed. Now, there's an exception to that. So if you've got something that's like a really, let's say, tight franchise, like a McDonald's or some other restaurant chain, where you've got very tightly prescribed recipes and methods of production and layout of the facility, and you've developed goodwill for that particular presentation of food, you've got that goodwill extends nationally and internationally in the case of something like a McDonald's. On the other hand, something that's a much looser franchise, or one where the personal services of the franchisee play an important part in developing customer goodwill. So I think of something like a fitness center, or a cleaning, a janitorial service. The goodwill basis for a restrictive covenant is going to lead to a more limited scope to where those personal services were actually performed, and where the customers gained a relationship with that person. Let's go to the next slide, please. One of the things that has been a topic of discussion in franchise non-compete cases is whether they're judged by the standards that the state has developed for employment non-compete covenants, or are they judged by sale of business standards. And that matters because the employment standards are much stricter. They generally permit a shorter duration, 2 years or perhaps 3 in some states, and a tighter geographic restriction focused on the activity of the covenantee, the employee. Whereas sale of business standards are much more permissive. Longer duration covenants, 5 to 10 years, are upheld, and the scope is defined more broadly. And the other big difference is blue penciling. And by that I mean the ability of a court to enforce a restrictive covenant to some degree less than its express terms. And in other words, the court can modify or grant an injunction that's less than the full scope of the non-compete if it has concluded that the full scope of the non-compete is too broad. That is almost universally available in the sale of business context. It is not at all universally available. Varies quite a bit from state to state in the employment context. Next slide, please. So most states now judge franchise non-compete covenants by employment standards. And the cases on this are summarized at 7 and 8 of the outline. North Carolina has adopted a hybrid test that combines some factors from employment covenants and some from sale of business. But generally, we're looking at employment standards. Next slide. Before I get into the trees, I want to talk about some other categories of distribution relationships besides franchise, and these are addressed in the outline. So a manufacturer's rep. The case law generally holds manufacturer's rep covenants to the employment standards. And the same is true of independent dealers. And of course, restrict covenants with independent dealers may trigger some antitrust scrutiny, but that's outside my scope today. So in the trees section, I want to just talk about some very recent developments that might be of interest to you. Next slide, please. The first one is a very recent decision from the California Supreme Court that is a marked departure from that state's treatment of non-competes that we've all gotten to be familiar with, perhaps. In California, there's a provision in the Business and Profession Code that is, on its face, a per se ban on restrictive covenants. But in this case, Ixcel Pharma, the Supreme Court unanimously ruled that as to a exclusive dealing arrangement between two companies, such as an independent dealer may enter into with a manufacturer, a rule of reason applies to those. In this case, the covenant was in a settlement agreement in a patent case where one party said the other was precluded from working with anybody else to develop a particular kind of drug. And at the time that the parties entered into this settlement agreement, the covenant, or the person who's saying they wouldn't work with anybody else, was working with somebody else, so they had to terminate their relationship with that party, and that's Ixcel, and Ixcel filed this lawsuit to challenge that settlement agreement as an unreasonable restraint of trade. Next slide. And the court said this is that this Business and Profession Code 16600, which is the source of the per se ban on non-competes in the employment context, applies but does not impose a per se ban with respect to business restrictive covenants. Next slide. And so that's a very limited the court's decision in the Edwards versus Arthur Anderson case, which is only 12 years old, limited that to the employment context and cited franchise and distribution agreements as examples of reasonable and pro-competitive restrictions. So this is very good news for manufacturers in California. Next slide. Here's another case. This is from a Minnesota court, but dealing with North Carolina law. We can go to the next slide, please. There was a covenant that barred the franchisee from, after termination, engaging in a business that was competitive with or similar to the franchisor's restrictions, the franchisor's business. Next slide. Let's go ahead and skip to the next slide. We're getting kind of short on time. And there was a case law in North Carolina that said a restrictive covenant that prohibits engaging in a similar business is invalid because you only have an interest in being protected from competitive business. And that's a holding that the Wisconsin Supreme Court made in an employment case in Star Direct. Next slide, please. And the court in this Mainstream case didn't adopt that position, but this was just in the context of a motion to dismiss and held there were factual disputes. But so it remained to be determined in Mainstream whether this covenant would be overbroad because it covered similar businesses. Next slide, please. This is a case from Ohio about an ice cream franchisor, and we can skip to the next slide. Again, here's the restriction that is barring a competitive or similar business. Go on to the next slide, please. And here the court upheld that restriction as valid in both Ohio and California law. We can skip to the next slide. And let's go to the next slide. The last topic I want to address is some recent case law on the issue of irreparable harm. The most common remedy for restrictive covenants is to get an injunction, and to get an injunction, you have to prove irreparable harm. There's a difference among states and courts as to whether the violation of a restrictive covenant is presumed to give rise to irreparable harm. Next slide. And we can go ahead and skip to the next slide. So we've got a couple of cases here from the last year where the courts are reaching different results on that. In this LA Insurance Agency franchising case, they applied Michigan law, and you can skip to the next slide. And they said irreparable harm can be inferred from a finding of breach of the contract. Next slide, please. Here's one from Iowa, GM case. We can skip to the next slide. And the court, the GM had made some very specific arguments about why breach of this. This was a covenant not to have another manufacturer's products in the same dealership. And GM had some very concrete arguments about how that would cause irreparable harm. But as we go to the next slide, we'll see the court rejected that proof, although they spent 20 pages analyzing it. They said GM's testimony was speculative, and the court could not imply irreparable harm merely from the fact of breach. Next slide, please. And this is an older case, but one that really irks me because the court's reasoning on irreparable harm was, well, you're franchisor, you're a big operation, and so in terms of your overall operation, one franchisee's breach doesn't cause irreparable harm. Of course, you know, that ruling repeated over and over again would destroy the franchisor. It seems to me you've got to look at the irreparable harm question in relation to the particular location. I think I've probably exhausted my time, but that's some recent developments in non-compete law. I'm happy to answer any questions. I see there's one on Any tips to narrow the scope of ability to use residual information post-termination? And by residual information, I think this is a reference to information, you exchange confidential information. You probably have a provision in your agreement that says you have to give back all the documents. If it's a franchise, give back the manuals and so on when you terminate. But we see frequently now covenants that say, talk about the residual information, that what you've retained in your memory from having been a franchisee for this time, even though you no longer have the manuals. And some of those restrictions are very onerous. I think you've got to, that's really an area where you've got to push for, if you're representing the covenantor, you've got to push for a short duration on that kind of a restriction, and maybe try to negotiate for definitional terms about what is residual information, because when you're dealing with highly detailed manuals, it's not something that typically stays in someone's memory. So you ought to be able to narrow it to things that are real trade secrets, that that do stick around after the manuals are gone.
All right. This is Bobby again. Thank you, David. See, there's a couple of other questions, and we'll make sure that we respond to those separately offline following today's presentations. We're going to take a break right now, give everybody a few minutes to get up and get a glass of water, make a trip to the restroom, etc. We will reconvene at 1:30 sharp. Thank you. Okay, everyone, we're back from our short break, and we're going to start with our next round of sessions. Our first speaker in this segment is Nate Imfeld. Nate is an associate in our Milwaukee office and a member of our distribution and franchise practice, as well as our litigation department. And he's going to be talking about, have you UCC'd my shipment, third-party logistics. Nate?
Thanks, Bobby, and thanks everyone for being here this afternoon. As Bobby mentioned, my name is Nate Imfeld, and I'm going to be talking about third-party logistics today. And I'm very excited about this topic, partly because in these distribution and franchise seminars, we usually spend a lot of time talking about legal jargon, and third-party logistics gives me the opportunity to address a topic of business jargon for the first time. So before diving into a specific definition of exactly what we mean when we talk about third-party logistics, which I'll do in a moment, I wanted to first take some time to talk about why I think you ought to care about third-party logistics. So first and foremost, I think that if you're on this call, there's a very great likelihood that you make stuff and sell stuff. And if you make stuff and sell stuff, you need to move that stuff around, whether those are goods, inputs that are coming into your facility before you manufacture, whether they're partially completed goods that need to be moved from facility to facility if you're using different factories to complete different aspects of the product. And then, of course, finished goods have to move out into your distribution channels. And franchisors don't think that you're off the hook here. Although you may think you primarily sell your brand or your system, logistics touches every aspect of the franchise business, particularly from the perspective of your franchisees. So I think this is an important topic for franchisors as well. But at bottom, third-party logistics is about moving stuff around. So that's one reason why I think folks ought to care about it. The other reason I think you ought to be interested in third-party logistics is that this is a thing that is happening. You've got many companies, whether it's your companies or your competitors, who are leveraging third-party logistics providers, and they're doing so on a really extensive basis. Depending on how you measure the marketplace, third-party logistics providers have roughly doubled their market size every year for about the last 10 years. So you or your competitors are using third-party providers a lot. So from your chair, I think you need to understand what third-party logistics is, what the providers do, where the risks are, and work out how to mitigate them ahead of time. So 2 reasons I think you ought to be interested. So what do we mean when we say third-party logistics? So at bottom, we're really just talking about outsourced storage or transportation services. Then that can be at the less sophisticated end of the spectrum, services that have been around for a long time, right? You engage a third-party warehouse to store your stuff, or you get a third-party trucker to come in and move some stuff around. But one of the reasons this is an interesting area of consideration is that this has become much more sophisticated just in the last decade or so. The services that are being offered are far more complex and touch on far more pieces of your business than had previously been the case. So for example, third-party logistics providers offer a service that usually gets called transportation management, which really means that where before you might have decided, all right, I need to move my good from point A to point B, so I got to go out and find a freight provider. I got to find a trucking company to move the stuff. I've got to find someone to insure it. I've got to find someone to do drayage, to move it from one truck to another truck, or from a truck to another form of transportation. I need to find a warehouse to store it before it needs to move. You would have to do all of that work yourself, and a third-party logistics provider that's offering transportation management services takes all of that off your plate. Similarly, value-added warehousing covers things like, in addition to storing the good, the warehouse might do packaging. They might kit stuff together for you before it goes to your customers. They might handle your returns. All of these different services. And then dedicated contract carriage is a common one where you can actually essentially buy the use of a truck and a truck driver from a third-party provider on a per mile basis. So you use only as much trucking service as you actually need. You don't have to do any more than that. So those are sort of common services that are underneath the umbrella of third-party logistics. So what are some of the advantages of third-party logistics? Why are people using it? So one, and this is usually the one that gets people's attention, of course, is cost, right? So it's less expensive to use a third-party logistics provider than it is to own your own trucks or own your own warehouses and pay people to work in them. That cost piece is just simply because third-party logistics providers can spread costs out over a larger customer base than you can, and they're less likely to have assets that are laying fallow. But there's an additional advantage for companies that want to use third-party logistics, and part of that is that it takes those assets off your books, right? So it makes transportation and storage less capital intensive, which can be something that is desirable for a given company. Third-party logistics, as I was describing, right, also takes complicated decision-making off of your plate and puts it on the plate of someone else. You simply say, I want this good to move from point A to point B, and they take care of it. Scalability, right? So we were talking about the dedicated contract carriage allows you to say, well, today I need 10 trucks and tomorrow I need 5. I don't have to own 10 trucks and let 5 of them sit on the days when I don't need more. You only pay for what you use. An important advantage also is competency. So third-party logistics providers only do logistics. They only do shipping or storage or provide those services. And so they're good at it. At least generally they're good at it. And they're likelier to be better at it than a company whose core competency is really making stuff and selling stuff. And then the final consideration that people are usually focused on when they're thinking about using a third-party logistics provider is liability. So by not owning the trucks or buildings themselves, you take the liability off of your company if something happens, if someone has an accident or if the building catches fire, that's no longer on your plate. So with those things in mind, you might think, sure, I mean, we're all set then, right? I mean, great advantages. You've got, all of these costs and stuff like that. So you guys are all ready to head out and into the third-party logistics world and sign people up, right? Yeah, not so much. And of course, you're probably expecting me to say that. That's what we lawyers do. We tell you about all the terrible risks that you face. But I do think that there are some important aspects of the third-party logistics space that you should be paying attention to from a legal perspective. And before I get into the details of that, I think the framework that we should think about using for this is simply that all of these new services, new offerings, new things that third-party logistics providers can do for you exist on a framework, a legal framework that was really developed in the early part of the 20th century. That's when it was codified, right? So we have common carrier rules and statutes and warehousemen, which is what they get called in the statutes often, rules that were developed in common law and originally codified in the very earliest versions of the Uniform Commercial Code. And so we really have a problem, a disconnect between the legal rules that apply to these relationships and the modern reality of how complex these relationships have become. So that plays itself out in certain common problem areas. So problem area number one, most common, is loss or damage to goods that you've given to a carrier or to a warehouse. And the issue you have in this space is the UCC default rules give warehouses and shippers special rights that they can deploy against you. So I'll just give you an example. So let's imagine that you've got a good. And we're going to use a warehouse as an example, as opposed to a shipper, but the rules are roughly the same for the two. So you've got a good, you've given it to a warehouse, and an accident happens. Forklift tips over, the pallet breaks, but the good is damaged, maybe even destroyed. And you rightly would expect that the warehouse would take responsibility for the damage to your good. The issue is that they will come back and tell you that their liability for the damage to the good is limited to the weight of the good. They'll say, well, we're only responsible for 50 cents per pound of whatever it is we broke. That's the measure of our liability. And sorry, you're out of luck. And that quirk, which sounds sort of unreasonable on its face, is actually baked directly in to Article 7 of the UCC. They are both shippers and warehousemen are specifically empowered to limit their liability in exactly that way. And if you want to claim that your good has a higher value, you needed to tell them ahead of time that it was more valuable than their sort of default liability limitation provision allowed for. This same issue crops up with an additional twist in the area of theft. So the same limitation applies to theft. It's a loss in the same sense. The only exception to that is if you can prove that the shipper or the warehouse converted or stole the good for their own personal use, which is of course very difficult to do, certainly if no one got arrested or caught for the theft. And it's also difficult to do because that limits, that exception is defined to include the warehouse itself, right? If the warehouse is a business, that company, not its employees. So its employees would have to have been acting on behalf of, for the benefit of, the warehouse or the shipper in order for them to be held responsible for the full value of the liability. Otherwise, the liability limitation provision we've been talking about applies in full. And so you've really got a tricky situation when it comes to goods that you've consigned over to someone else where these UCC rules apply. Another common problem is liens. So perhaps not all that commonly known, but businesses, warehouses, shippers, carriers who can take advantage of these UCC rules can actually take your goods hostage in the event that a dispute arises between you and them. And this has come up numerous times for clients of ours. In fact, I can think of one example in particular where we had a client who had in effect all of their inventory with a third-party warehousing company that ran into some financial difficulty and essentially held those goods hostage to force our client to try and force our client to pay them off and bail them out of their financial situation. And that situation becomes really, really difficult to manage if those goods, as they were in that instance, are critical to the operation of your business. So you have to bear in mind that these lien rights can cause the ordinary sort of contract, balance of power, if you will, between parties to tilt strongly in favor of the shipper or the warehouser. And then finally, I'll talk about termination as a common problem. And I know termination is a very common topic for us to address at this seminar, if you've been to seminars of ours previously. But when we're talking about termination in the franchisee, franchisor, or dealer, manufacturer, or supplier space, it works a little bit differently. So termination in this area, right, is fairly straightforward. It's a matter of contract law, or the default rules are pretty much you can terminate for any reason or none. The tricky piece here comes in when you realize that those rights come with a very short fuse that can be used by the service provider as well. So for example, a warehouse can fire you on 30 days notice. If you have a large amount of valuable goods stored at that warehouse, you may find it's difficult to find a replacement service provider in the time allotted. So you might need to address that ahead of time, give yourself additional time to think about it. You also have different considerations when you're dealing with goods in transit. You don't want to be in a situation where the shipper, once you've terminated the contract with them, simply has the right to drop the goods off at the nearest location and leave them there, right, and not complete the shipping contract. So you have to address that. And all of these situations become even more complex when you layer in those third-party service providers. So you may have a situation where the company that you have an agreement with is a service provider that then subcontracted with the trucking company. What happens then? Who gets to direct where the shipment goes? Who's responsible? So these are all considerations where problems crop up, again, because these default rules are really envisioning a much simpler time that does not incorporate, or doesn't take account of, I should say, all of these additional complexities in the third-party logistics space. So some key takeaways, some key things to think about as you're working through third-party logistics issues. I think probably the most important one from my perspective is to not think about these relationships as being casual. Traditionally, right, if you're giving, if you're signing something over to a common carrier at your loading dock, or you're, causing something to go into a warehouse where it's just going to sit for a while, there's a certain casual relationship you have with that. Often, the trucker might hand you a pre-printed form and it's got terms and conditions on the back and you just sign it, right? It's not a situation where you would ordinarily think that you need to negotiate any terms. But I would submit to you, it actually is. This is particularly where you're using these more sophisticated third-party providers that are doing more than simply moving stuff around or letting stuff sit in their property, right? Where they're doing additional tasks, taking account of the fact that the rules are stacked against you and negotiating some of those terms is important, and especially important, right, to establish the value of the goods. If you are regularly moving high value, especially high value goods that don't weigh that much, you might need to write into your agreement with your service provider that their liability is not limited in the way that is envisioned under their form contract. And if you are moving goods that vary a lot in either weight or value, you might need to establish a process where you can tell the shipper or tell the warehouse what the value of the good is before you turn it over to them. Finally, I'll point out that this is a space where, you've got very highly sophisticated computer-based third-party logistics providers doing really interesting, logistics management stuff. And you also have providers that are doing exactly what I just described, handing you a pre-printed form contract that hasn't been revised since 1976. And they're covered by the same rules and they are operating in the same space. And so for purposes of managing your contracts, I would just make like it's 1920 and keep everything, right? Don't allow documents that are going to control your legal destiny end up getting tossed or stuck in someone's desk drawer. And when a conflict arises, you can't find them or you can't establish what happened with the goods. So in addition to those key takeaways at a general level, I'll mention a couple of points about UCC Article 7, which if you look at the outline, that's a lot of the law that's cited here, in addition to, the usual cases reciting misery, which we throw in there to make it clear that there's nasty stuff that can happen to you. But UCC Article 7, the top line consideration here is that if you are the person storing the goods, right? You are the one consigning the goods over to a warehouse or to a common carrier. The UCC Article 7 default rules are not there to help you. They were written for the benefit of the warehouseman or the common carriers. And so to the extent that it's possible, right, to negotiate different rules and explicitly depart from the UCC, I think that's a wise decision. Also, if you get into a dispute with someone, that's probably the first place you need to look to find your answers or to understand the legal background against which that dispute is going to play out. And then finally, I think perhaps the most important consideration is understanding what your risks are before you engage a third-party provider. So you really need to vet them, to investigate them and understand how their business operates so that you can adequately assess your risk. So one particular consideration is understanding the difference between asset-based and asset-light service providers. And the basic difference there is simply that asset-light providers don't own any of their own stuff, right? They don't own the trucks. They don't own the buildings. They're providing the services. They're often like the software-based companies that are helping you manage your logistics process. And that's great, but ultimately, if you give your goods over to someone, it's going to end up on a truck, and the truck is going to be owned by someone, or it's going to end up on a boat, and the boat is going to be owned by someone. And so understanding how their business works and how they source their service providers can be a really important part of that process. You also want to research ahead of time. There's been a lot of merger activity in this space, for instance. So understanding whether or not a 3PL provider you're using has recently been through a merger and is in the integration can be an important consideration. And to the extent you can, you want to understand what their customer service is like. So with that, I think there's at least one question here in our queue. So the question is, we use one of our distributors as a 3PL. Customer has no liability and only pays once product is shipped. Since, oh, sorry, hang on. Before I just finish reading this here and make sure there's nothing that we wouldn't want disclosed. not sure I read a question in here, but the customer has no liability for the inventory. Oh, I'm sorry. Is there anything on the legal end to make customer accept inventory moving forward in the future, 1 year from now? So if I'm understanding this question correctly, you've got a distributor that is acting as your warehouseman, basically. You're shipping product to them that they are not on the hook for, so this would be a situation where your relationship with them as a warehouser and your relationship with them as a distributor are probably controlled by different contracts, would be my assessment there. From a third-party logistics provider standpoint, you really, I mean, if you don't, you really should have a separate agreement with them for those services. I mean, if the distributor is just hanging on to product for you that's really still on your books, there should be a separate agreement that controls what they are and are not obligated to do. Now, if you're talking about a distributor that you're trying to force to essentially take inventory rather than simply sit on it when they're not selling it, there are business ways of putting pressure on them, but it's really a question that's going to depend a lot on the specific state that you're in and what the specific rules are in that state. So it looks like I've got that question. We got some contact information, so I'll follow up with them. But really, the two considerations as a 3PL provider, if you're combining services that way, a distributor and a 3PL provider, my big takeaway would be there needs to be two different agreements for those different aspects of the relationship, with a very clear understanding of when they touch each other and what happens when they do. So I think if there are no other questions, I will leave it there. I'm pretty much right on time. So thank you very much, and I appreciate your attention this afternoon.
Wonderful, thank you. At this time, we will make our second CLE code announcement. For those seeking CLE credit today, please type the 5-digit code into the Q&A box with your email and hit send. It is imperative to send your credentials and the code to receive credit for today's program. Again, if you need the attorney affirmation form, it is located in the survey link in the Q&A widget. The second CLE code is GK16Q. Again, that is G as in George, K as in King, the number 1, the number 6, and Q as in Queen. One more time, the second CLE code is GK16Q. Thank you very much, and I'll turn it back over to our moderators.
Right, thank you. We're fortunate to have as our next speaker, Matt Lee. Matt is a partner in our bankruptcy practice group. And as many of you know, with the pandemic, bankruptcy has been in the news quite a bit lately. Many American companies, iconic American companies, have been filing for bankruptcy. Matt's topic is of particular interest to distribution and franchising because he's speaking on the subject of insolvent small businesses, recent changes in the law. Of course, many franchisees, dealers, and distributors are themselves small businesses. Some have been or may be facing bankruptcy, but also manufacturers and franchisors, large and small, rely on franchisees, distributors, and dealers to offer their trademark goods and services. So this is particularly timely. I'll turn the floor over to Matt to address these changes.
Thank you, Mike. And welcome everybody. It's good to be with you again at the annual DNF seminar. Hope to be with you in person again next year. It's funny. Mike mentioned that you're fortunate to have somebody on the line talking about bankruptcy. I'm never quite sure if that's the case, just because I feel like people tend to like talking about bankruptcy or hearing about bankruptcy as much as they like hearing about divorce. So I'm always a little lonely at these things. But as Mike pointed out, it's a fairly timely subject. It seems like every day there's a different retailer or a different energy company or a different, well-known manufacturer filing bankruptcy. So it's kind of an uncertain time. We are seeing a lot of not only the big newsmakers, but a lot of small businesses that, frankly, keep the economy running and keep you guys running. People you do business with and have done business with for a long time. If we could go to the first slide, we can talk about a recent development in the law that was extremely timely, and it's almost as if it was made for this time, because I think it's going to be a positive development that helps a lot of your small business partners get a second lease on life when otherwise they'd be in big trouble given the circumstances we're facing. So what I'm going to talk about today is the Small Business Reorganization Act, which was signed into law by President Trump last August 23rd. It was one of a number of bankruptcy reform bills signed into law, but this was the big one. This was probably the biggest change. Bankruptcy law doesn't change.
Sorry, I'm having trouble hearing you.
Bankruptcy law doesn't change very often. I would say once a generation you have a major rewrite of the code. I wouldn't call this a major rewrite, but it does employ some significant tools and some important tools that weren't there before. I don't know how often we can say this, and I, after what we saw on Tuesday night, I don't know if we're ever going to be able to say this again, but this bill was passed with broad bipartisan support. Very few people opposed the Small Business Reorganizations Act. And I think in part it was because it was developed from proposals by leading bankruptcy thinkers, and specifically bankruptcy organizations like the American Bankruptcy Institute, the National Bankruptcy Conference, the American College of Bankruptcy, and it was endorsed by the National Conference of Bankruptcy Judges, which it's what it sounds like. It's an organization comprised of the bankruptcy judges from around the country. I believe they're all members, or certainly nearly all members, and they put their heads together and looked at this and said, yeah, this is good law. Next slide, please. Just a little bit of background on what prompted the SBRA. Small business debtors tend to be the least likely to reorganize. And when I use the word reorganize, I'll just back up a little bit. You guys have probably all heard of, either from presentations you've heard me give or others give, or just from your practices. Bankruptcy is organized into different chapters. You got Chapter 7, which is a liquidation, can be used by individuals and companies if they're just shutting down. Chapter 11, which is reorganization, generally used by companies, although individuals can take advantage of it as well. And then the other big one is Chapter 13, which is for individuals who have slightly more assets and more manageable liabilities than those who have to liquidate and start all over under Chapter 7. Tangentially, there's also Chapter 12, which applies only to fishermen and farmers, which we're not going to get too in depth into those here, because the SBRA deals only with Chapter 11 cases. Which is the reorganization chapter. And one of the things that the authors of the SBRA and that the organizations I identified earlier noticed is that small business debtors tend to be the least likely to reorganize. And, just for some reasons for that, they tend to have limited assets. They tend to have significant secured debt that operates as a lien on all of those assets. So the bank is in first place on absolutely everything. And oftentimes their equity, the people who run the company, started the company and run it, is the engine. It's what makes them go. It's their most valuable asset. And under general Chapter 11 principles, equity isn't allowed to stay involved in the business. They're not allowed to continue as they're not allowed to continue in their position if they unless they pay all their creditors in full, which almost never happens. So they lose their equity holders, and they kind of lose what makes them a working business. The other thing that prevents small business debtors from reorganizing, or makes it hard for them to reorganize, is that bankruptcy is just expensive. The first day you file a bankruptcy, you've got to file sometimes up to 12 or 15 motions just to keep the lights on, just to keep operating as you did before, paying your insurance premiums, paying your critical vendors, etc. And then you've got a lot of reporting and disclosure requirements when you're in bankruptcy. It takes away from your ability to operate your business. You can basically have two full-time jobs. You're satisfying your reporting requirements, you're answering creditor questions, and you're running your business. Professional fees, lawyers, auditors, financial advisors, investment bankers are very expensive. And then you got creditors committees, which is another expense for the debtors, because they've got to pay for unsecured creditor committee professional fees like attorneys and financial advisors. And so what the SBRA does is it creates a new subchapter 5 in chapter 11 that is exclusively for small businesses. And in doing this, they've altered the definition of what is a debtor. The debtor is, as you know, it's the name of the company in bankruptcy. So it's American Airlines, it's Enron, it's General Motors, okay? But under subchapter 5, it's defined as a person engaged in commercial or business activities, and a person can be an individual, corporation, or partnership, whose aggregate, non-contingent, liquidated debts, whether secured or unsecured, are less than $2,725,625. And that's indexed for inflation every 3 years, as you can see on the slide. And at least half of that has to arrive from the commercial or business activities. So the authors recognize that, a lot of small businesses, they also carry a lot of debts of their equity holders. And they said that, look, at least 50% of your debts have to be specifically related to the business. And by the way, this is how the statute was originally drafted. We're going to see an amendment in a slide or two. But the good thing is, this bill was signed into law, as I said, in August of 2019. It became effective in February of 2020, right before the pandemic really got bad here. And, frankly, in spite of some statutory language suggesting otherwise, every court that has examined it has decided that anybody who filed before the law became effective in February of 2020, they can convert their case to subchapter 5 if they otherwise meet the requirements. So next slide, please. As I mentioned, the SBRA took effect on February 19th, 2020. The advocates of the bill actually wanted that $2.725 million liability threshold to be $10 million, which I personally think makes sense, just given what $10 million is these days compared to, say, when the bankruptcy code was enacted in 1978. But then along came the pandemic, and obviously very unfortunate event, but for purposes of subchapter 5, I think Congress wisely, as part of the CARES Act, it's one of the many things they did under the CARES Act, raised the liability limit to $7.5 million. This is a 1-year temporary raising of the limit. Right now it's scheduled to sunset on March 27th, 2021. I don't know who Marcy is. That obviously slipped by the censors and editors, but it should say March 27th, 2021. If I had to predict what Congress was going to do, I'd say Congress is going to do nothing. But I think there's probably going to be support, just depending on where we are, to at least maintaining that liability limit of $7.5 million after March 27th, 2021. And who knows? I mean, maybe they'll listen to the people who advocated for the bill in the first place and push for $10 million. We'll see about that. Next slide, please. All right, so there's kind of 4 big changes under the Small Business Reorganization Act. I'll go through them quickly here, and then I've got slides on each of them, except for the last one, which I'll kind of start off right away. So first, you're going to have a standing trustee instead of an unsecured creditors committee. So a standing trustee just means that it's a fiduciary who's going to be appointed in a neutral fiduciary who's going to be appointed in every subchapter 5 case that is going to kind of monitor how the bankruptcy goes and what the debtor is doing with its assets and what it's doing to repay creditors. Second big change is that only the debtor can file a plan. Right now, if the debtor doesn't file a plan, and any of its creditors or its banks decide they want to say, all right, well, this is how we're going to reorganize this debtor, they can do that. Under the SBRA, under subchapter 5 cases, the debtor is the only party that can file a plan. The absolute priority rule, which is the rule that says that I alluded to it earlier, it says that all creditors must be paid in full before equity can maintain its interest, and by extension that all creditors of junior priority, none of them can be paid until the creditors of senior priority can be paid off. That is out as to unsecured creditors under subchapter 5, and it's replaced by something called the disposable income test, which I'll describe in a moment. And then finally, the drafters, they really threw creditors a bone by kind of automatically fast tracking these cases. They recognize that these these businesses don't have to sit in bankruptcy for months and months and months before developing a plan. So there's got to be, rather than an expensive first day hearing on all those motions I mentioned earlier, there's got to be a mandatory status conference within 60 days after filing. And the debtor has to, unless they can show extraordinary circumstances, they have to file their plan of reorganization within 90 days. The earlier iteration of the Small Business Act, which was really not much at all like what we have now after February of 2020, allowed small business debtors to wait 300 days, so 10 months, to file a plan of reorganization. It was interminable, it was frustrating, and you never knew what was going on. That has been dramatically shortened to 90 days. Next slide, please. Okay, so what is the standing trustee? The standing trustee, if you're an unsecured creditor in a subchapter 5 bankruptcy, the standing trustee is your best friend. You're gonna be calling the standing trustee a lot, because the standing trustee is an independent monitor that has absolute oversight over the debtor. It doesn't take over the debtor's business, unlike in Chapter 7, where a fiduciary is appointed to liquidate and distribute the assets. The debtor in subchapter 5 cases, like other Chapter 11 cases, remain in possession. So the standing trustee doesn't have to have any particular business acumen, and they don't have to conduct fire sales. But what they do have to do is make sure that the case stays on track, at least through plan confirmation, and then make sure that the debtor makes all payments that are required under the plan. The standing trustee still gets paid out of the estate assets. They get paid on a percentage of the cash distributed. Next slide, please. And these are just a handful of duties. These are all laid out in the statute. I'll go through them really quickly. The trustee needs to account for all property that is received by the company, either that it brought into the bankruptcy with it or that comes into the bankruptcy after it begins, including after the plan's been confirmed. They get to look at every claim that's filed against the company, and they can object to claims as they feel necessary. They get to review the company's financial condition and business operations. They have some minor reporting requirements that you'll be able to track. They have to report fraud or misconduct to the bankruptcy court. And obviously that's a public report. So when the court finds out about it, you'll find out about it. They have to assist as necessary the facilitation of a plan of reorganization. So if the debtor's counsel is struggling and I suppose it remains to be seen as to how extensive this duty extends. Does the trustee have to be involved in any negotiations with creditors? That has yet to be ruled on. As I said, it's a brand new law. But the trustee is there to help facilitate the plan of reorganization and then finally make sure that the debtor adheres to the plan that the court approves during the payment period, which typically will extend between 3 and 5 years. Next slide, please. Okay, so I mentioned that the second big change is that only the debtor under subchapter 5 can file a plan. You may have heard of something called the exclusivity period or motions to extend exclusivity, and that's because under a typical Chapter 11 case, under Section 1121 of the Bankruptcy Code, the debtor has the exclusive right to file a plan of reorganization or liquidation, any Chapter 11 plan, up to 120 days after the petition date. And then the debtor has the exclusive right to seek extensions of this exclusivity period up to 18 months from the petition date. Those motions are routinely granted by courts. It's a very powerful tool for the debtor. It basically allows them to silence dissenting voices and keep them out of the room if they don't want to hear it and they don't want the court to hear about it. The downside of, I guess the upside of making sure that the debtor is the only party that can file a plan in a subchapter 5 case is that it makes things simpler, makes things less costly, and it kind of, you don't have as many backroom, in theory, you won't have as many backroom machinations and shenanigans as you would in a bigger case with a bunch of constituents lobbying for their piece of the pie. The downside is that a creditor fighting confirmation can't propose their own plan. All they can do is object to confirmation or seek dismissal of the bankruptcy case. The other thing is that subchapter 5 eliminates the disclosure statement requirement. Under Chapter 11, every plan, and if you've ever gotten one of these plans in the mail, you've probably gotten a longer, equally or more confusing document called the disclosure statement. The disclosure statement is meant to tell you all sorts of things about the debtor, how they fell into bankruptcy, what their plan is for getting out of bankruptcy, what the tax implications on the debtor is, of the Chapter 11 plan that's being proposed, whether reorganization or liquidation. And a lot of times it takes up more space and is less useful than the plan itself. And sometimes not, but a lot of times it is. And so subchapter 5 says, look, small business debtors don't have to monkey around with this. The plan is the plan. And the bankruptcy courts have developed good forms that kind of make the plans a little more streamlined to lessen the, I guess, impact of not having a disclosure statement. Now, a court can order a disclosure statement if it wants to, but it doesn't have to. Next slide, please. Okay, so the third major change is the absolute priority rule, as it's typically functions in a Chapter 11 case is out. Again, the absolute priority rule requires claims to be paid in full or in order of in the order of their priority, unless the creditors otherwise consent, or unless the debtor can show that, look, the value of this claim is actually much lower than what's being claimed by the creditor. And therefore, I only have to pay this particular creditor a certain percentage of its claim before I can move on to payments to the next priority class of creditors. Well, in subchapter 5, the SBRA leaves this unchanged for secured creditors. So banks can still rely on getting paid whatever it is they're owed under ordinary Chapter 11 law in a subchapter 5 case. But if we go to the next slide, this is the bad news, guys, because I know a lot of you guys are, suppliers, or you receive supplies. You don't typically have secured claims. Can we go to the next slide? Thank you. The SBRA eliminates the absolute priority rule for unsecured creditors and replaces it with what's called the projected disposable income test. So you're not totally out of the money. In fact, the plan will only work under the statute if there is some disposable income to be dispersed to the subchapter 5 debtors' unsecured creditors. And how it would work is that the debtor has to basically budget out its next 3 to 5 years, however long the plan period is, and it has to, accurately and using some kind of credible methodology project how much money it's going to need to just operate its business over the course of the next 3 years under the plan, or 4 or 5 years under the plan. And any income taken in by the debtor that is not needed to pay expenses necessary to continue to operate the business goes to the legacy creditors from before the bankruptcy was filed. In order for the debtor to get a plan like this approved, it has to show that it can or is reasonably likely to make all plan payments. And the subchapter 5 trustee is going to have a strong voice with the court as to whether the debtor can meet that requirement. So if we go to the next slide, it's also the last slide. So I've just given you kind of a law school lecture. So what does this mean for you, practically speaking? Well, the first thing, which I think you'll appreciate, is that you're just going to get your results quicker. You're going to know much earlier whether a subchapter 5 debtor is going to liquidate its assets, whether it's going to try and reorganize, whether it's going to do something in between, whether it's going to bring in new equity, new board. You're going to know that sooner because of the 90-day requirement for the plan. And practically speaking, it's just going to be less expensive no matter what your role is in the case, because there's only so much you can do with a subchapter 5 debtor. And I think, relatedly, there's going to be less shenanigans. You got a trustee as fiduciary that reports to the court. You don't have a creditors committee, I represent a lot of creditors committee. That doesn't mean there's a lot of shenanigans, but you're going to have less estate money going to lawyers, and that's just not a factor in subchapter 5. And then, it's like I said, it's also pretty formulaic. The statute pretty much spells out what needs to happen in one of these cases. So there's going to be a little more certainty and a little less room for backroom dealings carrying the day over the code. Downside is you're probably going to have less power just because, you're not going to have as much negotiating room to say, hey, give me a better deal and I'll let you assume my franchise agreement or my dealership agreement. It just isn't going to work that way. A lot of those protections are still there, but the money is just going to be limited. And at the end of the day, if you're an unsecured creditor, you just got to kind of wait and see what the debtor proposes. And then finally, you've got a potential for the equity you've got the potential for the existing equity holders to stay involved in the business. And, you know, you may love the equity holders, you may hate the equity holders. So depending on where you come out on that, this could be a change for the better or for the worst. I don't see any questions. If anybody has anything, I think you probably got 15 seconds to submit it. If not, my email address is mdlee@foley.com, and you can reach out to me anytime you want.
Thank you, Matt. Typically, when we have a bankruptcy presentation at the seminar, even when it's live, the questions are preceded by the phrase, "I have a friend too."
Yeah.
But seriously, if anyone has any questions, as Matt said, please feel free to submit them by email. And if we don't have time to answer them during the seminar itself, we can follow up by email later. We're going to conclude the program today with a presentation by Laura Ganoza, a partner in the litigation department in our Miami office, who has a particular specialty in trademark law, on the subject of brand protection in Latin America. And this is often a topic of discussion at our annual seminar. Several years ago, when we did this live and in person in our Los Angeles office, a client there, a manufacturer based there, was approached by someone in Brazil claiming to be the company's sub-franchisor. And the client's response was, well, we don't have any franchises or sub-franchises anywhere, much less in Brazil. Well, it turns out actually they did. Their distributor in Brazil had been offering sub-franchises without their knowledge. Fast forward to 2019 and 2020, and Laura is actually working with Leslie Smith and me on a case involving that I think really touches all the bases of trademark protection in Latin America. Our client is a U.S. manufacturer that recently took back its overseas distribution and found out that there's a company claiming to be its dealer based in Miami, but claiming to be the dealer in Dominican Republic and Colombia. And this case now is not just a 3-ring circus, but a 4-ring circus. It's in federal court in Miami, the International Chamber of Commerce Court of Arbitration in New York. We're in front of the trademark agencies in Colombia and the trademark agencies in the Dominican Republic. So we're very fortunate to have Laura present on this topic because she really does have her feet, hands, everything in all of these jurisdictions, knows what she's talking about. And with that, I'll turn the floor over to Laura to wrap up.
Thank you, Mike, and good afternoon, everyone. And it's not lost on me that I am the last person on this session, so thank you all for hanging in there. I really appreciate it, and I'm happy to be able to talk to you about this because, as Mike said, this is something near and dear to my heart. I practice in this area all the time, and these issues unfortunately come up. So hopefully we'll give you some good pointers if you're doing business in Latin America, or more importantly, if you're planning to expand your business into Latin America. So if we can go to the next slide, please. So important thing to remember is Latin America it's made up of 20 different countries throughout South America, Mexico, Central America, and the Caribbean. It's I've listed them there for you. You'll see I have Puerto Rico in brackets because it's considered part of Latin America, but for trademark purposes, trademarks in a federal U.S. trademark will be enforced against any infringers in Puerto Rico. So although it's considered part of Latin America, your U.S. registration, if you have one, will give you rights in Puerto Rico. That said, you could always file a trademark application in Puerto Rico and seek protection there in that territory, and it'll act just like a state registration. But the really important thing to know about Latin America and trademark rights is that they are national rights. So if we can go to the next slide. This is really the main point that I want to impress upon you all today is, you know, unlike the European Union, there's not one single LATAM protection that you can get. There's not one depository where you could say, plant your flag and say, I want to register in all of these 20 countries and have protection throughout. Unfortunately, these are trademark rights are national rights. And in order to have protections in Latin America, you have to go and get protection in each country. So that's something very important as you're planning your strategy of what you're going to do and where you're going to go in Latin America, because generally your protection just stops at the border of that country. Now, there are some exceptions, and I'll talk to you about that later in the Andean community, but for most part, you need to go into every different country and get your national rights there. So if we can go to the next slide. And what happens if you don't? This is what Mike alluded to. It's a case that we have going on now. If you fail to seek your trademark protection, you can lose them, or it could be very, very expensive to get them back. And why is that? The reason is because in most Latin American countries, they establish trademark rights on the basis of trademark registrations. You actually have to have a trademark registered in order to be recognized as having trademark rights. That's very different than what most of us who practice in the US are used to, because in the US, we have a first to use type basis. And that means that whoever uses it first gets rights, whether or not you have a registration. So that's really important, because you could be the minute you slap your trademark on your product, or you start advertising your services, or you start distributing with that mark on it, you have rights, whether or not you have a registration or not. And you could go against third-party infringers even without a federal registration. Now, as a trademark lawyer, I'm going to tell you it's a great idea to get your marks registered because you get all kinds of additional rights, but it's not necessary in order to establish the rights. So if we can go to the next slide, please. So instead, what you have to do is go into every country, like I mentioned, and get your trademark rights that way. Now, I know that a lot of you probably on this call are managing your budgets, your legal budgets and your legal spend for your organizations, and you're thinking, wow, that's going to be expensive, because if anybody does practice in the trademark area, they know that, a registration in one country could be a couple $1,000 for each mark, and then for each country, and then, that kind of multiplies very quickly when you're dealing just with Latin America, that's 20 countries. So I wanted to bring up that there is, in some cases, there's an ability to try to get rights in a way that may be more cost effective, and that's called the Madrid system. And this is it is a central repository, and what you can do is get one trademark, and it's called an international registration. It's a bit of a misnomer, because what it is basically you file with the World Intellectual Property Organization, known as WIPO. They're located in Europe, and you file a base application that acts as your base base trademark registration, and then from there you can designate all of the countries that are part of this Madrid treaty. And there are some pros and cons for using it. It's a really good way to do it effectively in certain instances. So if we can go to the next slide, I could explain some of the pros and cons about this. So as I mentioned, it's a central filing system. So here you are, you can just file. It's great. You can file in one country, in one language, so you can do it in English. It's much more efficient because everything is done through WIPO. So if you ever have to make a change to, let's say you have a name change, or your company went through an acquisition, you can just make the change right through that system. You can change your goods and services. If you are no longer in a product line, you can delete those goods. So it's much easier to do that. And if it's a relatively straightforward and you don't have any objections, as you're applying for the mark. You don't even need to get local counsel. So what you can do is, have your base registration. Let's say it's based on the US registration, and then you can designate all these other countries where you want that trademark to be registered in as well through this system. So those are all the pros. It's great. But we're here today to talk about Latin America. And unfortunately, one of the biggest cons, if you are dealing with Latin America, is that the countries of Latin America have not really embraced the Madrid Protocol or system. There's very few countries in Latin America that are part of the system. You have Colombia, Cuba, and Mexico, and Brazil just became a signatory right at the end of 2019. But so it's very limited number of countries in Latin America that you can take advantage of this with. But it is an option if these are some of these countries are ones you're interested in. Now, another important limitation of the Madrid system is that it's dependent on that base application. So remember I mentioned that, okay, you'll start it out with you start with your US based application. And if anything should happen to that registration from the United States, that's your base registration, that same thing's going to happen in the countries that you've designated. So if for whatever reason you stop using that mark in the United States and you're not able to continue to maintain that registration, you lose that registration in all those countries. So they're dependent all on the base application. So that's a really important consideration. You need to make sure that the trademark itself, where you have it registered, that forms the basis of that international registration is strong, so that you can maintain it, because everything else is going to rely on that. Also, even though you're filing it through the Madrid Protocol, every single national office is going to still review it under their local laws. And if the trademark application passes through the prosecution process without a problem, no objections, then that's great. It's smooth sailings and it's much cheaper. But if there are objections raised, you're going to need to have local counsel. So, let's say you designate, Colombia, in the Colombia Trademark Office is still going to look at that under their rules to make sure that the trademark applications passes muster from their perspective. And if it doesn't, you have to hire a Colombian lawyer to help anyway. And then lastly, for this is very important, you still have to do enforcement in each country. So there are some pros and cons, and I just wanted to give this to you guys as an option, but unfortunately in Latin America, Madrid is not always the best way to go. So instead you're looking at getting your rights in each of the countries. So if we can go to the next slide. And so this is how do you establish your trademark rights in Latin America? They're established by getting the registration. And this is what I mentioned before, that unlike the United States, where in the US it's first to use, you have common law rights from the moment you slap on your trademark. In most Latin American countries, it's just based on the registration. So even if you're the prior owner, even in the case that Mike and I were talking about, our client is the owner of that trademark, but somebody else got there first, and they have a trademark registration. So that's what you need. That's all you need in Latin America. Now, there are a few exceptions to that. If we can go to the next slide. These are the only places where these countries do recognize a first to use type system. So it's Costa Rica and Uruguay, because as I mentioned, Puerto Rico is under the US system anyway. So unless you're going to be in Costa Rica or Uruguay, you really should look into going to and making sure you're the first one to get your trademark registered there. And I think Will Ferrell's character, Ricky Bobby, in Talladega Nights said it best for what you really need to do in Latin America. If you ain't first, you're last. So that really is the key. And the reason for that, if you go to the next one, and especially for you folks on this call, it's because of these third parties, that even parties that are affiliated with you, or worse yet, parties that were affiliated with you, they can be the first one to win the race to get the registration, and you as the actual true trademark owner needs to go in there and fight to get that trademark back, because not only can the prior registration from a third party prevent you from registering your trademark, what's worse is that it could prevent you from using the trademark in that country, because that owner has the trademark rights. By being the registered owner of that trademark, they could actually prevent you, the actual brand owner, from using the trademark and selling the products or offering the services in that country. So in this respect, a lot of those countries in Latin America are much like in China, where, you know, it's the same kind of thing where your rights come from being first to file. So Latin America is that same kind of system, and that's why it's so important to be there first. So all is not lost if you're not, but it can be expensive and time consuming in order to get it back. So I'm going to run you through some of the ways that you can do it if you're ever in that situation. So maybe if we can go to the next slide, please. And this is what Mike was mentioning with our case. We are litigating in so many different fronts. So if you are a victim of this and you are the rightful owner of a brand, but you realize somebody else got there first, there are things that you can do. And it all depends on where in the process the registration or application is. The first one is known as opposition proceeding. And this is if you catch the trademark application before it actually registers. You can file what's called an opposition proceeding in many of these countries. And that happens before it actually gets registered, and it's a time period when a brand owner can go in and say, no, I object to you registering that trademark for the following reasons. And in order to be able to take advantage of that, it's really important to sign up for worldwide trademark tracking services. You know, we help our clients with that all the time. It's really important as a trademark owner, wherever you're using your trademark, to protect it and to make sure it's not being infringed. That's actually an obligation of a trademark owner in order to maintain those rights. So if you take advantage of a tracking service, there's services that actually advise you when a third party has filed a trademark that's similar to yours, or when a trademark that's similar to yours has been what's called published for opposition. And that's at the point where you could actually file an opposition proceeding against them. So if you don't already have those trademark notices in place covering Latin America, I encourage you to do that, because that's a great way to find out what's going on in those countries. If for some reason you don't catch the third party in time and the mark already registered, you still have the ability to either cancel or nullify the trademark. And again, this is also an administrative proceeding before that National Trademark Office. And I'll go through some of the grounds, but there's not that many grounds, so you're going to have to fall into one of the grounds to get the mark nullified or canceled. One of them is to cancel the mark based on non-use, because at some points in time, most of these countries, even though they don't require use to get the registration, in order to be able to maintain the registration, they have to actually be using the trademark. So after a certain period of time, it's usually between 3 and 5 years after the registration is issued, the trademark owner, better have some evidence that they're actually using the trademark. otherwise you as the brand owner can come in and file a cancellation or nullification action based on non-use. And then lastly, there's also litigation. If, at the end of the day, they're, you want to stop them from using the mark, or they're, trying to stop you from using the mark, you can get embroiled in litigation as well. So if we can go to the next slide. So if you're not the first one to actually file the trademark application, what can you do? There are these exceptions that some of the countries recognize. One of them is well-known marks. Basically, if you have a very, famous mark or mark that's gained what's called notoriety, and you're able to prove that, then most of the countries have a provision in their rules that say that a third party cannot register a well-known or mark that's reached notoriety, because it's almost as if it's bad faith, and so they don't let them. So that's one of the exceptions. Also, if it's a trade name, some countries have exceptions that do protect trade names, even if they're not registered. That's good, but obviously it's not going to protect your specific product lines or, any of your actual trademarks that don't just refer to a trade name of your company. So that's another one to keep in mind, but again, it's more limited. And then prior use, but that's in very exceptional circumstances. And in all of these, you're going to have to provide significant evidence. So let's go to the next slide so you can see the types of evidence that you're going to have to produce. And this is how it gets expensive, right? So you're going to have to do survey evidence in some cases if you want to prove notoriety, to make sure that, yes, these companies, people in that country recognize this trademark as famous. Sales information, advertising information, anything that shows how long you've been using the mark in that country, in that specific country, and you're advertising in that specific country. So all of these things become expensive. We can go to the next slide. This is one exception that I wanted to make sure you guys were aware of. When I mentioned that you needed to have a registration in every country in order to protect yourself in that country, there is one exception for these 4 countries in the Andean community, for Bolivia, Colombia, Ecuador, and Peru. Those countries have a little bit of a, cooperation agreement. You don't get one trademark and then it's good in all 4 countries. You still would need to register in each. But if you don't have a registration in each, they have some reciprocity. So if, let's say, for example, you do have a registration in Peru, but there's a third party who's trying to get their mark registered in Colombia, and you don't have a registration in Colombia, you can use your trademark from Peru to be able to oppose that one. And similarly, if somebody is trying to attack your trademark in, let's say you have a trademark in Bolivia, but given some of the conditions, you haven't been using it lately, someone's trying to attack your trademark in Bolivia saying you haven't used it, you could actually use the use, let's say you're using it a lot in Ecuador. You can say, okay, well, I'm actually using it in Ecuador, and that'll be enough to save your registration in Bolivia. So this is one example of where there is a little bit of collaboration between the countries. So then, to sum up, if we go to the next slide, how could you protect yourself in Latin America? Be the first to file, really think of a business plan. And I always tell clients to think about, where are they expanding in terms of sales and where are they manufacturing their products? And those are the places you want to get your marks registered. Think of it as a 1-year plan, 3-year plan, 5-year plan. Where do you want to be at those? Where are you going to be manufacturing and where are you going to be selling those years? And then file before you get there. Another consideration and another tactic to use to protect your trademark, if we can go to the next slide, which is also the last slide, is to include provisions in your contracts with your distributors or sales reps. Make sure that they understand that they are not to register your trademarks. they shouldn't even be using your trademarks and their domain names or social media handles. You know, make sure that they understand that you are the owner and they are not to do that, and include strong post-termination obligations so that if for some reason you let them use it during the relationship, they have to immediately cease using it when the relationship ends, or they have to transfer a domain name back to you. They have to give you, you know, stop using the social media accounts. So that's another way to try to protect yourself if you have the ability to, if you actually have a contractual agreement with these third parties. And that's all I have, and I think I came in right under the wire. So let me know if you have any questions, or if you guys want to know anything else right now.
Laura, thank you very much. I didn't see any questions from the audience, but if people have them, they can be submitted on the Q&A feature, and you can respond later.
Great. Thanks, Mike.
You're welcome. Thank you.
Thank you, Laura. And thank you to all of our attendees for attending today's program. That brings our program for the day to a close. Before you log off today, please make sure you've entered your credentials one last time so we can track your attendance for CLE credit. If you included your contact information with any questions during today's program and we weren't able to answer online, we will follow up via email. And last but not least, just a reminder that we will be doing our second session of presentations for this year's seminar next Thursday, October 8th. And then last but not least, the third session, which will be on Thursday, October 15th. Next week's session will focus on international and compliance topics. And the last section on Thursday, October 15th, will focus on sort of the more traditional termination, antitrust, pricing types of issues that we talk about at each of our seminars. So hopefully you can join us for both of those as well. Thank you again, all of you, for coming, and we're looking forward to seeing you next week.